Welcome back to Law and Crime. Judge Ashley Wilcott here with you. You can see I'm excited. I have all these live guests. I forgot where to look. So you're listening to the judge who is ruling on, there's a witness that the prosecution wants to call. He is stating all the reasons behind, and we don't yet know whether or not he's going to allow the prosecution to call this witness. But this witness would be expected to testify about internet searches, specifically something on Merritt, the defendant's cell phone, about a search or changing identity, or a photograph that came up with a changing identity. We need more information on that. And the judge is determining whether or not those things are going to be admissible, if that witness is going to allow to be called. Now, the jury is not in the courtroom, which is typical when you have motions. The judge has to rule on that outside the presence of the jury, so that's going to happen. And then we're going to have to see what the judge decides. Now, I'm really excited this afternoon. Two of my very favorite guests are here. Joining us via Skype, we have Judge Birmingham from Dallas, Texas, and Ross Kramer, criminal defense attorney. I love having you in studio, so thank you both for being here. Let's delve right in. One of the first things I'm going to ask, and I'm going to ask you, Ross, is things like, are we allowed to call this witness? Why would this not have been decided, preliminary motions, before they even started trial?
I don't have a good reason for you. It should have been. In a case like this that's been brewing for years, with pieces of evidence that don't seem like they just came to the prosecution's attention, I don't think there's any excuse for it. And the reason is that the prosecution has to understand how their case is going to come in before they even get up to do an opening. If they're not sure if some of this evidence is going to come in, that could affect the way they're going to try their case. I would think that in any case with a conscientious prosecutor, whether a witness would be able to testify is something that would be addressed pretrial. Right,
and I completely agree. It's going to throw you off on your theory of the case if you are or are not able to call a witness that's part of the case you're trying to prove.
You would think so. Sometimes it's necessary when pieces of evidence come to your attention later on, or one witness you already put on says something you didn't expect and it leads down a different route. But this sounds like a witness that they should have known about and did know about before the case even started.
Absolutely. So, Judge Birmingham, let me ask you, talk to us about if you were the judge in a case and you're day 20 into a trial and now you have this motion about, no, this witness shouldn't be allowed or should be allowed. How would you handle it as a judge?
You try to take care of these things as quickly as you can during the pretrial process, but when one side or the other tells you that something is or is not relevant, it's really difficult for the court to really know what is and is not relevant until the trial kind of starts. So you do have to take time during the middle of the trial because now you know what the evidence is like. Now you can really weigh the factors of admissibility against the factors of prejudice and make a decision at that point. So not entirely unusual. The lawyers have to war game. The judge is going to make a decision. This stuff is coming in or it's not. They've got to be ready to go. But the judge we're getting a really good look about what the judge is doing in his function as a gatekeeper at this clip right here.
Absolutely. So this is live. We're going to dip back into court to see where the judge is now. So again, thanks to the great team at Law and Crime, I have some information about other things the judge said and decided during this dialogue, and we're going to take a quick break. We're going to come back to that and return to court live here on Law and Crime. All right, so Detective Hankey had a subpoena to get access to QuickBooks information from Intuit, and they allowed him online access as if he were one of the people that had those accounts, 2 accounts over 1,000 pages, couldn't copy that information. So what he did have to do is take screenshots of all that information. Now, I have to ask you, Judge Birmingham, what do you think the prosecution is trying to prove with his testimony?
They're trying to develop the motive on behalf of the defendant that he was killing, which might indicate that the reason that this motive has been from the very beginning on the part of the prosecutor, that the defendant was upset about a business deal and went after Mr. McStay and the family because of it. And this might prove, kind of like in the old days, if there was somebody milling about a safe or something like that at a bank. The reason why is because they wanted to get the money, and that appears to be what they're saying right now through this witness.
All right, so let me ask you, Ross, one of the things as a trial lawyer I always loved to do was use demonstrative evidence. And by that I mean, if I'm going to have all these witnesses, each testifying to a very small part of the story that I'm putting together, I will use flip charts. I will use something to put all the pieces up so at closing it's easy to paint the full picture for the jury. They're not doing any of this. Do you think any of this testimony is being lost on the jury?
You know, I think demonstratives are very helpful, especially with jurors in this day and age that are used to getting their information in some kind of multimedia experience. They're used to seeing things as well as hearing things, and that reinforces the way that people learn. But I think in this case, because there's so many little pieces of evidence, I don't mind them coming in this way. I think that the prosecution in their opening should have said, you're going to hear evidence coming in piecemeal, and I'm going to get back up in front of you at the end of this case, and I'm going to tell you how this all ties in. So the jury has reasonable expectations, and that they're going to wait to hear at the end of the case what the prosecution's theory is and how they put these little pieces together.
Great advice. So tell them what they're going to hear, let them hear it, and then tell them what they've heard. We're going to take a very short break and come back, and we'll join the trial live after this short break. All right, we're hearing more testimony about very specific things. And Ross, we were just talking on a break, so I'm going to bring it to you first, and that is, what's the import of the fact that all the letters, first letters, and all the names on QuickBooks are capitalized? What's the significance?
I mean, my understanding from having followed the trial is that there was an entry made in the QuickBooks to Charles Merritt. There was originally a Charles Merritt in the QuickBooks account with the C and the M of Charles and Merritt capitalized. But shortly before the disappearance, there was another account created with Charles Merritt with the C and the M in lowercase. So I think the implication is that someone else made that entry, not the family. Now that, as far as I've seen, that doesn't tie it directly to the defendant, but we'll see what else they can put forward. Right,
and the evidence. So Judge Birmingham, let me ask you, do you think, you know, every witness is kind of saying this, here's this evidence about what's in QuickBooks, it's the motive that you've already discussed with us, but how does that tie it to the fact that they're alleging this defendant actually killed these 4 family members?
Well, there's something that has struck me about this case as I've thought about it. If the motive is money, if the motive is all about money in QuickBooks, the one problem that they have is one of the motives that was expressed at the crime scene, where the wife's bra was cut, and it appeared as though that her clothes were in such a way that they might have been indicative of sexual assault. Well, that does not comport with the motive that's being offered against this defendant. They have to deal with that. And by the way, you have the killing of an entire family. What's the motive against the children, for example? What is that all about? How is that tied to QuickBooks? And I think they're going to have a real problem with that.
All right, thank you, Judge. So we're going to take a quick break and come back right after this with more of the live trial here on Law and Crime. All right, so we're listening to his testimony about the records that he had subpoenaed, and he was actually logging onto the computer to look at QuickBooks. Judge Birmingham, I know you'll be leaving us at 3. I'd like to give you an opportunity. First, what do you do to make testimony a little more riveting to the jury? Is there anything that can be done? And second, anything else you want to add after watching some of this testimony today?
Well, one of my favorite rules of evidence, especially in the day and age of cell phone records, is the summary of a voluminous document. Here you've got a number of records. Please use that rule if you're a lawyer trying to make things digestible for the jury. I like to watch newscasts and see how they do it. They've got a clip up, they've got a video up, or they've got some kind of a graphic, and you can really codify and solidify your argument and your point if you narrow it down as quickly as possible to a very digestible diagram, maybe a summary. 50 calls, 50 checks were written between this day and this day from an account that didn't belong, something like that. There's rules out there, and these lawyers need to use them.
All right. Anything else that you've noted that you want to share with us in your expertise that I always value and appreciate?
Well, I really appreciate that. First of all, I'm really curious to see how they're going to match up the proposed motive, which has to do with QuickBooks, with the way the crime scene appeared, and how they're also going to try to marry up the allegation that Kavanaugh did it, and what holes with the allegation that Kavanaugh did it could be filled by the prosecutors in defeating that and saying that Merritt's really the one who did it. So it'll be really interesting to see.
It really will be. So, Ross, just really quickly, are you having a hard time having to pay attention to this witness, given all the tediousness of what they're going through?
I can only imagine that the jurors are having a very hard time trying to pay attention to this, especially without demonstratives where they're presenting what the documents actually look like.
All right. We are going to have to take a break, but we will continue to cover this trial live. You will not want to miss it. We're going to be back here on Law and Crime in a few minutes. Come back on the other side of this short break. Welcome back to Law and Crime. Happy to have you here this afternoon as we continue to cover California versus Charles Merritt. We've been following this trial. I have to tell you, I'm a little frustrated, but of course they didn't ask me to hear the case because they did start at 11 o'clock today Pacific time, 2 o'clock Eastern time, because the juror did need to go to a medical appointment. Understandable, absolutely. However, after 1 hour in court, they've now taken a lunch recess. We understand that they'll be on an hour-and-a-half break for lunch for the jury, and then they'll come back. So what we're going to do at this time is, first of all, let's start. Aaron Keller has done an amazing summary of this case to catch us all up to speed as to where we are.
How does this family of four disappear off the face of the earth?
California small business owner Joseph McStay and his entire family disappeared February 4th, 2010. Their car was abandoned near the border. Authorities believed this video showed them fleeing to Mexico, presumably to avoid business debts. Case closed? Not even close. Fast forward more than 3 years to November 2013. A biker discovered the skull of one of the family members in the Mojave Desert.
I was traveling on a dirt road. I stumbled across the remains.
All four were buried nearby. Authorities arrested Chase Merritt, a business associate to Joseph McStay. They believe he killed for money.
The why boils down to greed and greed's child, fraud.
The defense says Merritt didn't do it.
Charles Merritt was here because Chase. That was his best friend.
The state has presented a $4,000 check from McStay to Merritt, made out the day McStay disappeared. But Merritt never cashed it. He told police there was always money.
That they are Joseph McStay.
Someone with at least some access to McStay's business accounts tried to change his QuickBooks software right after McStay vanished. The state also presented cell phone searches for information about the family's disappearance made by Merritt shortly after the family's bodies turned up in the desert. In those graves, a hammer prosecutors believe was the murder weapon. Also, shards of a bath mat. Authorities think it matches linens missing from the family's home.
They were beaten about the head and face until they died.
The family's home, prosecutors say, is the crime scene, but evidence is scant.
You will look for things, signs of violence, correct?
Yes.
And you didn't see any of them?
No, sir.
One officer who took photographs there realized back at the lab that she may have found blood on the family's table, but she didn't see it when she was in the house, and it was cleaned before anyone knew it was there.
When I saw it, I was horrified.
Why?
Because I thought it was something I missed.
The defense is pointing to an alternate suspect who also did business with the family and to unknown DNA found in the family's graves. This is Aaron Keller reporting for the Law and Crime Network.
Thank you, Aaron, for that great summary of the case. Now I want to introduce, we have another guest. Ross Kramer still with us. Thank you for being here. Mike Korobonics is here with us as well. Thank you for joining us today.
Thank you for having me.
Criminal defense attorney, former prosecutor. I'm going to put you on the hot seat first, because here's my question. We know 9 years of circumstantial evidence is required in this case for the state to prove beyond a reasonable doubt that this defendant killed these family members. 6 months is what's been estimated as the amount of time for that trial. Do you believe 6 months is how long it should take to try a case like this?
Well, I think when you have, I was involved in a case, it was a RICO case that lasted 4 months and the judge had us in every day. It's a big strain, but a 6-month case in a circumstantial evidence case with only one defendant seems a little bit of a real slow grind, if not reverse. seems like a long time.
And you mentioned you just came out of a federal trial. Tell me, in that court, were you in court the majority of the day? Did you have long breaks or start late? How did that particular court run the courtroom?
Well, that court ran it more accurate than most train stations and most train lines, because we started at 9 o'clock. We had a 15-minute break at 11. We went till 12:30, 45 minutes for lunch, so everybody be ready at 12:30 till 4 o'clock in the afternoon every day, and the case moved along rather smoothly. And I think jurors appreciate that more because they're not hanging around. You know, jurors want to get on with their life. To make these kind of commitments, it's rather difficult.
All right. Ross, tell me your opinion about why it might be taking so long to try this case. What do you think? You shared with me grasping at straws. What do you mean by that?
I mean, I think it's taking so long to try this case because they don't have the direct evidence that actually will prove their case. If you have the goods, you should be able to show it to a jury. You should be able to introduce it in an opening statement and through your first few witnesses lay the groundwork and show why this is a case that deserves a conviction, especially in a capital murder case. I think it's a sign to the jury and everybody watching when you need to take 6 months, when you're going off on all kinds of directions and all kinds of tangents, that you don't have the goods in a case like this.
So it's going to be interesting to see because they are presenting witnesses that all have a very small amount of information, and so far really it's been about the money trail and the motive. Let me ask each of you, Ross, I'm going to start with you. If you're the prosecution and you believe that the motive is money, is that where you're going to start proving the motive?
Well, I think that's the strongest part of their case, so I agree that that's probably where they want to start it. But you have to remember, motive is not an element of the charge that they're trying to prove here. You don't have to prove any motive for a murder. This is something that a prosecution usually wants to prove because a jury wants to hear a story and wants to understand the why. But they're going to need a lot more. You need to give the jury the why and then explain to them when it happened, where it happened, how it happened, the actual meat of a murder case, and I don't see that here.
So, Mike, is the motive enough? Do you think that's going to get them through on this case from what you've seen so far?
No, especially in this case, because now they have some other people who may have had motives. I mean, if you want to have one motive to one defendant that you're prosecuting, I think you need to make sure it sticks to that defendant. It can't be an alternate motive that could go to the other person who the defense is pointing at. I think the strongest point of this case, and I don't think it's strong, but it's all relative in this case, is the cell tower that puts him near the burial site where they found the bodies at some point in time. That's a difficult one to explain away, but I still don't see it being supported by much of a foundation. I think they're going to have a difficult time.
All right. So what we're going to do now is return to a clip of more testimony in this case. Let's listen.
Pages 2, 3, and 4, I am seeing Google searches that were conducted on February 8th.
And if I could just, let me just, that would be Exhibit 827. So back to my question, would that be the report that would tell us what time that internet activity would have started on February 8th?
Yes.
Okay. So would you mind, and you don't remember what that was, correct, off the top of your head? Would it refresh your memory to look at that document to see?
All of these records containing last access time between 2:06 a.m. and 2:07 a.m.
Okay. So for about would it be fair to say then on February 8th, somebody is actually at that computer doing some internet activity that you described on Thursday, correct?
Yes.
And when I say somebody sitting at the computer, I mean there's internet activity that is sometimes that the person doesn't have to do anything on the computer, just does it on its own. Virus scans, things of that nature, correct? The system will do it on its own.
Yes.
This is different because this is actually somebody sitting at the keyboard punching keys, correct?
These records would suggest that, yes.
Okay. So somebody is at the...
There you saw a cross-examination of Detective Schroeder. Now, again, Detective Schroeder is the one who testified on direct that someone used one of the 5 McStay family computers, that they were on it for approximately 1.5 minutes to 2 minutes. He did clarify that, no, he could not say. He does not know who was using the computer. Let me start with you, Mike. What's the relevance? What's the import?
I don't see it, and actually I don't even know why they're bothering cross-examining this witness to give him further credibility, because when he says, I don't know who did it, and your position is it wasn't my guy, it was someone else, I think you just let him go and let him forget about it, especially if the case is going to go on for 6 months. They're going to forget about him pretty soon if you don't give him some credibility through cross.
All right, but let me ask devil's advocate, Ross. So they're able to show through this witness, yes, somebody was on the computer. Maybe they have another witness that's going to show, hey, at the same time, this is what the defendant was doing. He was on the computer trying to cover it up. I mean, I don't know. What do you think? Reasonable or not?
I don't think that we should give that much credit to the prosecution in this case based on what they've shown. They had their chance in opening statement to lay out the facts that they were going to put before the jury and the way they were going to prove their case. They didn't bring up anything like that. We haven't seen anything through this witness that shows that they're going to connect this to relevant, real hard evidence upcoming in the trial. So it feels like another witness that's largely going nowhere.
You know, to me, it's been interesting to watch this trial. I feel like instead of culling out the pieces that are important for prosecution to prove that this defendant did it, they're just throwing out everything. It's more like the investigation versus actually trying the theory of the case. Ross, I'm going to ask you first. What's your opinion?
You know, this is a technique you use when that's all that you have. You know, you see prosecutors, and sometimes defense attorneys have to do it too. You throw everything you have at the wall and you see what sticks. You hope that something will resonate with jurors. You hope that something later on will match up. But this is not a strategy born of strength in your case where you can say, these are the 5 facts, these are the 5 pieces of evidence that are going to convince you, jury, that you should convict in this case. This is, we're going to throw everything at you, and at the end we'll see if you can put it together.
Well, Mike, as a former prosecutor, let me ask you, is this a case you think you would have tried? Do you think that you could have proven beyond a reasonable doubt, based on what we've heard so far, knowing they still have a lot of evidence to present?
No, this would not be a case I'd be comfortable bringing as a prosecutor because of the lack of evidence, and I'd be even more uncomfortable if you put another layer on that they're actually going to go for the death penalty in this case. I think that's something that the prosecution as a unit, not just these trial lawyers, but the whole office in itself really should consider and think about twice before bringing this in front of a jury. Because this is dangerous. I mean, it's dangerous for both sides. There's nothing worse than having a weak case like this to defend because you don't know where they're coming from. So, like you said, at times you feel like you're in the middle of the investigation and they still haven't figured out what's going on, and you're trying to defend against that. That's fundamentally unfair to the defense.
Do you have any concerns that they have not followed the evidence, but have instead said, here's the theory of the case and who did it, and we're going to force the evidence to meet our conclusion versus we'll follow the evidence to see who did it?
I think they are working in reverse. I think they came to a conclusion and they're trying to backtrack, and that's never good.
All right. Ross, any other opinion about in terms of the theory of the case?
I mean, the theory of the case here may be that you have a family that wants a prosecution. You may have a community that wants a prosecution, that wants to air this publicly because people have died here and there's evidence that they were killed by someone. And I think sometimes prosecutors are susceptible to community pressure to try to bring a case, and you know, it never really turns out well when that's the basis of it.
All right, justice demands that the correct person is convicted, is found of this crime. We want to have the right person. Is Charles Merritt the right person? We don't know yet. Stay tuned. We're going to come back right after this short break to continue our coverage.
I mean, it's very, very hard, as you know, your other guests have said today, it's very hard to be a defense lawyer when you have no idea what the prosecution's theory is, what you're actually trying to interrogate a witness about and cross-examine a witness about. What points are you trying to get here? I would think you just try to go with basic questions about the fact that, you know, you testified this, but you can't tell who did this, who accessed the computer. You can't tell exactly when it was or what they were doing, and just leave it at that.
So let's talk about basic trial skills. Does a defense attorney have to ask questions?
No, absolutely not. I mean, there are a lot of situations when you wouldn't ask a witness anything on cross-examination when you think it could only get worse from where it is. If you think that a witness hasn't scored any points for you, or they've said things that are already favorable to you that you can pull out for your closing, why risk making it any worse?
That's right. So, Mike, I was always taught ask 3 questions if you have 3 questions to ask. But you don't need to ask 15, 20 questions. You don't want to go over the same testimony that's already been offered. Do you agree or disagree?
Oh, I agree. I think, I think a lot of lawyers make the mistake when they're on trial, especially defense lawyers, is they think they got to beat up on every witness. You're talking to a jury on behalf of your client. And the jury knows when you're scoring points and not scoring points. And if you go up and try to beat every witness up, you're just going to lose your credibility. Words are valuable. The less you use, the more the jury will listen to you. That's at least my theory.
Yeah, no, I don't disagree. And in this case, the jury is listening to a lot of attorneys ask a lot of questions. So we're going to go back now to more testimony from Michael West. Again, he's the business record QuickBooks special investigator from Intuit, to see what else he has to say.
I guess the September 30th date of 2010. Can we see it on this? So on September 30th, 2010, it looks like activity. What happened on September 30th, 2010?
Appears that Joseph McStay logged in and subscribed to the product, and then we jumped to September of 2014.
Now, you don't know if it's Joseph McStay or somebody else using the account.
I don't know.
That's just the name identified with the account.
That's the name identified with the credentials that were placed in the system.
Okay. And it only goes until October 13th, 2014. Is that correct?
From this document, yes, that's the last date.
Okay. So if anything happened after that, if data was changed or anything of that nature on the clone that you provided, it wouldn't be reflected here, would it?
Objection, Ms. Gates' testimony.
You can only, on the clone data that you provided, you can only say that nothing was changed up until October 13th, 2014?
Objection, Ms. Gates' testimony.
Overruled, yes, if that's correct. Can you restate that? I'm not following you.
Yes. You indicated that you gave...
And there you have it. Mr. West has certainly just testified that, yes, someone had access to QuickBooks, the online access. QuickBooks keeps a record of all of that access. We have subscriptions that were canceled. That's what we know from this witness. Take a short break. We're going to come right back, and you'll want to stay with us as we continue to cover the McStay family murder trial and analyze all of the interesting testimony presented thus far. All right, so let's recap what that testimony just told us. And it tells us that, according to QuickBooks, on February 1st, now remember, the 1st and the 2nd that he's talking about are a couple of days prior to the last sighting of this family. And there's testimony from him 3 days before they disappear that a check was produced to Charles Merritt for $2,500 on QuickBooks. And then an identical check was produced a few minutes after that. Now, after that, the user deleted both of those checks. Mike, I'm coming to you. So what?
That's my question. I wish I could find something to argue with you. I mean, it just doesn't make sense. Like Ross was saying before, who kills somebody for $4,000? I think that's an excellent point. I think you asked that to the jury, and it's sort of one of the things. I may retract a little bit. That's sort of like the thing you may want to cross on is, wait a minute, investigator, let me get this straight. That check was made out for $4,000, correct? Not $4 million, $4,000.
So let me play devil's advocate on that, because to a lot of people, $4,000 is a lot of money, but I can see perhaps killing one person in this case for money of $4,000. But the other 3 individuals, what if it resulted in they saw the crime, or the wife tried to step in and got killed as a result? The 2 little boys could identify him. They knew him. This was not an unknown person if, in fact, this defendant committed the crime. So then it's not just killing a whole family because of $4,000. It's the financial motive, and then he decides to kill Joseph, and then it ends up in circumstances he ends up having to kill the whole family.
Well, the problem is, though, this is not some sort of drug deal that went bad for $4,000. These are businessmen. I hope they know that you can't even find a lawyer to defend you in that kind of case for $4,000. So your investment of what you're trying to hide just doesn't make sense. And I actually think that was a great point that was made. It really doesn't make sense. And I don't think you'd go to someone's home to kill them over $4,000 or $6,000 and give them the benefit of the doubt. It just doesn't make sense.
All right. What else, Ross? I mean, it was your statement that you said, listen, are you going to kill a whole family over $4,000? So you think that's not a credible theory of a case?
Yeah. For me, you put 12 reasonable people in a jury box, and they go back into a jury room at the end of the case, and they take their common sense and their life experiences with them. And I think the prosecution is digging itself into a hole here to say that there's this extremely strong motive, and motive is really what is at the bottom of their prosecution, that this guy may have cut himself a check and then wanted to cover it up before it was discovered by his business partner, killed him, his wife, his children, the whole family, buried them out in the Mojave Desert, over $4,000 that he wrote to himself from his own business. I think this is going to be a tough one for them to swallow. You listed a wish list of evidence that the prosecution may have had, evidence that other people, the family saw it, so they had to kill the family too. That would be dream evidence for these prosecutors, and I can tell you for sure that if they had somebody saying that or they could support that kind of theory, that would have been the first 30 seconds of their opening statement, and it didn't come out here.
All right. All right, so here's what we're going to do next. Again, I love our producers here at Law&Crime because now we're going to go to the defense opening statements to hear what is the defense's response or position about the financial motive that the state claims the defendant had. Let's listen.
Then they say Merritt stole money from EIP after the family disappeared. They say he stole money. EIP is Earth Inspired Products. That's the acronym you'll hear referring to this company all the time. Checks were written on February 5th and backdated to the 4th. Well, they met on the 4th to talk about those two. And Joseph brought the blank checks to Chase to cover costs. We had forensic accountant Dennis Chauvin review all the financial records from the businesses, from Joseph, from Chase, and others. I'll cover the part he talks about this transaction. He said, in his experience of 20 years of tracing assets and seeing business valuations, he says all the monies received by Merritt after their disappearance would have been reasonable compensation and cost coverage to finish those jobs that were already in effect in February of 2010. Remember, they didn't get a financial accountant, so we did. That's what he told us. I'm sure my colleague will tell you what else he found. He had a practice of doing business with EIP and between him and Joseph. After handling something for Joseph, Merritt would always call him to update. So, he wrote 4 checks and deleted them at 12:39. Then he calls and leaves a message 10 minutes later. Hey, it's done. Then he's on the phone with QuickBooks for 108 minutes on the 8th. This is when they want to switch from online to desktop QuickBooks. Why do you do that? Online QuickBooks you can access from anywhere. And anybody can if they have your password. If you want to keep your business information from people you don't trust anymore, you switch to a desktop. Nobody can access unless you're sitting at that desktop. So that's what Chase was doing on the 8th. He's on the phone for 107 minutes. The technician's saying, yes, you want to transfer all information from online to desktop, no problem. After you do that, then I want to get rid of and delete the online account so nobody can look at anything anymore. Because all the information is saved on desktop. When they interviewed this woman, she said, yeah, that's common. People do that all the time. Then when he called, Chase called back on the next day saying, hey, yeah, I'm trying to do all this stuff. It's a new technician, and their notes are, he just wants to delete. Well, did you not read the notes from the day before where it says he's transferring first? They skipped that in their summary. He calls them for a 45-minute call. That call, well, first let's go back. 8th call ends at 4:58. He calls and leaves a message at 5:01 to Joseph. Everything he does, he calls. It's done. Hey, buddy, I don't know where you are, but this is done. Call again on the 9th, finish that call. 29 minutes later, hey, by the way, I finished all that. It's done. Not hiding anything. It shows he's updating Joseph, telling him, I'm doing what you told me to do. Joseph would actually always call Merritt, too. It's a shared practice. The checks that they talk about being deleted, they were created and deleted at 12:47. Joseph called Merritt at 1:03 right after. Joseph created more checks on the 2nd at 11:37. Called Merritt 3 minutes later, let him know, hey, yeah, this works. We can do it. Creates and deletes check on the 4th at 8:01. Last phone call at 8:28. Hey, it's done. That shows that Joseph's still alive when that car's leaving at 7:47. I don't know who was there. He's still alive, doing business. He's alive till the morning of the 5th.
Is defense's argument that this was reasonable compensation and that the prosecution's taken the money out of context going to win at the end of the day? We'll have to wait and see. Stay tuned. We'll continue coverage of this trial after this short break. Welcome back. I'm Judge Ashley Wilcott here for the afternoon with you, and we know that the Merritt trial should be resuming shortly, hopefully at 4:30 after they have finished taking their lunch break, and we will resume live coverage as soon as we're able, gavel to gavel. As soon as they come back, you'll be seeing it here first on Law&Crime. Now, in the meantime, let's talk about the prosecution's opening statement theory that the family was killed inside the family home. What type of evidence has been presented thus far to support that theory? Let's turn first to a neighbor who testified, and we're going to hear some of her testimony now and what she might have seen or heard.
Any signs of struggle or screaming or violence?
No.
And if you left the house at 7 o'clock in the morning, did you hear anything before you left in that week?
Not that I remember. If I did, I would have reviewed my cameras.
And if you leave at 7, what time is your general routine to get up?
5.
And like my wife, she gets up at 5. She'll take a shower first, then she'll eat breakfast and do her thing. Do you take a shower in the morning or in the evening? Generally at that time.
In the morning.
And would you have taken that shower the first thing and then got ready for work and done your thing?
No, I would have taken a shower probably at 5:45.
Now, you said at some point the camera system you set up was originally installed as always recording, and you switched it to motion detection.
Yes.
Was there something that you wanted to see that you couldn't see as recorded over because it was always recording? Is that what made you change?
No, it was just me thinking ahead and not wanting, I wanted it to last a while and not use up the hard drive. So I adjusted it.
On the always record setting, how much time could your hard drive save before you switched it?
The 24/7 would do about 2 months.
So it can save 2 months worth if you record it all the time?
Yes.
Did you have a function in there where if something wasn't important, you can save it so it's excluded from the auto overwrite?
Possibly.
Did you ever figure out that part of the system?
I didn't.
Do you know even if that system had that function?
I don't know if it did, I don't think it did, which is why they pulled it out on a hard drive. Or the other thing.
When you switched it to motion detection, did you ever have a chance to go back and look and see how much recording you could save on your hard drive after you switched?
Yes, it would go back about a few, I would say a few, so 3 or 4 months.
So you doubled your time.
When asked if she heard or saw anything, her answer was, I don't recall hearing anything or seeing anything. Now, she did testify that there was a video security camera that she had and that that may have captured some video. So, Ross, let me ask you first. This was a prosecution witness, and again, the theory of the case is the family was killed in the home. Why do you suppose the prosecution might have called this witness?
I have no idea why they would have called this witness. If you're going to try to introduce the video camera surveillance footage that might show a vehicle or might show an individual, I would think you'd call the law enforcement agent who canvassed the neighborhood, found this, reviewed the video, could show it to the jury, discuss it. Why call the neighbor to say that she has a video camera, but she doesn't remember hearing or seeing anything? At a certain point, there's a real risk the jury is just going to look at these prosecutors and say, what are you doing here? Why are you wasting our time with these witnesses?
Now, do you think the defense is going to bring up or raise the point that, look, if this family of 4 was brutally murdered with a sledgehammer, and you've seen the pictures of the skull with the blunt force trauma that killed these individuals inside the home, couldn't you make a good argument that somebody would have heard something if she was home as a neighbor? Something, a car coming, people coming and going, noise from the house.
Maybe. I mean, my only question, if I was cross-examining this witness, is to say, you didn't hear anything, you didn't see anything, why are you here? And then have her say, I have no idea, and that would be the end of it.
All right. So, Mike, talk about, you mentioned the Rule 403, and in terms of whether or not this witness should be allowed to testify. Tell us what you mean by that.
I think some of these witnesses, although they may have something, but it just seems like it's all speculation. I mean, there's a very specific jury charges that you can't convict somebody on conjecture, speculation, or things of that nature. I think Federal Rule of Evidence 403, which is adopted by most of the states, tells judges this may be relevant, but does it substantially outweigh its relevance with its prejudicial value? I mean, like, so there's a pickup truck. I don't know how many pickup trucks probably in that area. You got to have a little more for the prosecution to tie it together. And I think maybe the judge needs to pull the reins in a little bit here in his evidential rulings, and maybe we'll go from 6 months to 2 weeks.
So it's going to be interesting to see what happens. You're going to want to stay tuned. We're expecting that resumes live at 4:30. Stay tuned now. We have Aaron Keller with Daily Debrief. You will not want to miss it. It will give you all of the current information about trials that we are covering here on Law and Crime. I'm signing off along with my special guest, Ross Kramer. Aaron Keller's coming up now.